This is the American Law Journal.
Pharma commercials are everywhere. Lawyer commercials are everywhere. Should we be surprised they're banging heads in court? Who's winning? And how does that affect your life? Good evening. I'm Christopher Naughton. Welcome to ALJ. Pharmaceutical and medical device lawsuits, of course, are nothing new. But with so much money on the line and our nation's health at stake, pharma trials are really starting to grab headlines. Gina Passarella with the Legal Intelligencer has this.
Prescription Celebrex can help relieve arthritis pain.
Attention women who took Zofran while pregnant.
Pradaxa is progress.
Died from internal bleeding after taking Pradaxa.
You're down with Crestor.
Yes! You may be entitled to money damages.
Chances are you've seen one of these commercials today.
You may have a mass tort case.
And ask your doctor.
Ask your doctor.
Ask your doctor.
Ask your doctor? Really? What they're really saying is tell your doctor you need to have this drug.
Over the last 2 decades, pharmaceutical and lawyer advertising have given rise to a whole new phenomenon, the mass tort. Unlike a class action, in a mass tort, think Fen-Phen, Vioxx, or the recent hip implant or vaginal mesh cases, each plaintiff claiming injury from a drug or medical device, even as part of a large group, can experience different results. How people find their way into that group is where the controversy lies.
Cable television brings in junk plaintiffs. And I don't mean that in a disparaging way. These people are genuinely hurt, but there's no causation between their injuries and the claims that they're making.
It's kind of an absurd contention. You know, the reality is no amount of advertising alters the fact that the drug or the implant is defective. It's a way of shifting the blame from the company that produced and manufactured and failed to adequately warn about their products to the victim.
What plaintiffs' lawyers and pharmaceutical companies probably can agree on is this. More people are taking drugs, more people are claiming injuries from those drugs, and more of those people seem to find lawyers.
The amount of publicity given to these cases certainly has increased the number of plaintiffs in litigations. I don't think that's any question.
Today, people are searching the internet and, they punch in the injury that they have. Sometimes, not all the time, sometimes it pops up to a plaintiff's law firm.
Once these cases pile up, it's the courts that have to deal with them. If large enough, it could turn into a multi-district mass tort litigation. The question for pharmaceutical companies then becomes, how many cases to try, and when or if to settle them as a group? Consider recent litigation. Risperdal, an antipsychotic drug manufactured by Janssen, at the center of last year's $2.2 billion settlement with the federal government over fraudulent marketing. Now individuals in a mass tort group are suing the drug company for injuries.
There are over 250 cases that are actually filed in the court system. There are many young men who sustained this really very disfiguring injury known as gynecomastia, and that injury was not properly warned about.
Klein, who partnered with the Scheller firm in taking on Janssen, won a $2.5 million verdict in the first Risperdal trial. But just weeks later, in a second trial, Janssen prevailed, throwing a curveball at legal pundits as to which way this mass tort could go.
The most recent Risperdal cases, the objective in trying that first case was probably not the defendant's choice, but it may have been the worst case that the defendants would face. And so it would set a high ceiling while the second case would set a low ceiling.
Meaning in the long run, it's the voice of juries who signal liability and the value of mass tort cases, and whether or not it's time for a company to settle them all.
I think every mass tort sort of lives its own life. It depends on how the first couple trials go. First, how the defendants want to defend the case. It depends a lot, to be honest, on the pharmaceutical company that's on the other side and what approach they take.
We may settle cases not because we think we're wrong, but because it's just, from a financial standpoint, it's the best thing for us to do.
There's no doubt that technology and the media has played a role in pharmaceutical litigation, raising the profile of these cases and making it all the easier for plaintiffs' lawyers to find clients. The defense, on the other hand, is doing its best to limit damages and keep some of these cases out of court altogether. That tension is keeping the courts plenty busy. For the American Law Journal, I'm Gina Passarella.
For our guests weigh in tonight, let's go ahead and meet them. Terry Henry, For the defense, a commercial litigator, he represents and defends medical device and pharmaceutical companies, a partner with the internationally renowned law firm of Blank Rome. Chris Placitella returns to the program after many years, a partner with Cohen, Placitella, and Roth, the firm known nationally for its mass tort class action and asbestos litigation. Steve Scheller's been at it for 50 years, representing consumers injured by dangerous medicine and products. And joining us for the first time tonight, Jef Feeley, one of the preeminent reporters on pharma and medical device issues in the nation. He reports for Bloomberg News. Folks, we're not taking your telephone calls tonight, but if you have a question on this or any program we conduct here on ALJ, write to us at info@lawjournaltv.com. Well, one thing we always try to accomplish on the program is answer the so what question. Why is this so important to the average viewer? Let's take a look at some statistics. 70% of us in this nation are on at least one prescription drug. More than half of us take two. 20% of us are patients of 5 or more prescription medications. And most popular medications, antibiotics, antidepressants, antipsychotics, pain-killing opioids. Jef, I know that for many years you've been covering, again, pharma and med device issues, but I'd have to think over the last 10 years, it's taking up a greater percentage of your time.
It's true. The number of cases that have rolled in over the last decade have been enormous, and there's no end in sight. The consumer advertising that has been going on over the last 10 to 15 years has resulted in the wave of litigation.
And Terry, I think it's got to be about the amount of money that's involved here. I mean, again, we're talking about, in some cases, billions of dollars.
Well, money is an issue, but I think what's really important, what we all need to keep in mind is both drug and medical device companies are filled with scientists and people trying to come up with cures and treatments for patients out there. And they're responding to requests from doctors, and they're responding to requests from the field. And so what we've got to realize is all of these lawsuits is a huge challenge, not only once they get those products on the market to help people, but to keep them on the market.
The problem is that when the doctors were making the decisions in these pharmaceutical companies, we were in a different place. Now the marketing people and the business people are making the decisions. They are driving the media, and the doctors who, dedicate their lives to doing the right thing are really marginalized in the decision-making process. And I would argue that that's one of the main reasons we end up in court, because profits become more important than the quest for doing the right thing all the time.
It seems to me also that a lot of folks don't know immediately that the drug they're taking might be the cause of the problem. For example, if they're taking Cipro or Levaquin, they don't know right away that the reason that they had an Achilles tendon snap or a detached retina has been caused by the drug that they're taking. So sometimes these cases take a long time to filter through the system.
Well, they do. Risperdal is a good example. Boys were growing female breasts, and they thought it was just weight gain. And no one learned about it until plaintiffs' lawyers were starting to advertise. The problem is there's so much information being hidden by the drug companies, the lack of responsibility of the directors of the companies and the shareholders. So I keep saying somebody's got to go to jail at a high level, and more than one person, because we see so much information which is critical to the safety and efficacy of these drugs not being disclosed or being actually hidden.
So Terry, Steve says pharmaceutical companies are not playing fair, but I think there's also been some criticism of plaintiffs' attorneys going out, garnering business, bringing people into their mass tort lawsuits. A lot of lawyers are trying to bring in plaintiffs that have good cases, but occasionally, and we found out in court just this week, sometimes plaintiffs' attorneys are stuffing some pretty bad cases in there.
Well, I think what we learned with the Fen and the Vioxx litigation was huge numbers of plaintiffs can garner huge settlements. And as a way to pump up the value of a certain amount of cases, they advertise on the internet, they advertise late at night on TV, and they just bring in as many plaintiffs as possible, as many potential plaintiffs as possible in order to pump up the value of those cases. And what I think J&J found out in the vaginal mess cases as well is there's call centers out there. Somehow they find out that women have had surgery, and they call them up and they'll say, look, do you want to be part of this plaintiff in this litigation? And even in those cases where the women said, I didn't have vaginal mesh inserted, they say, well, do you want the money anyways? And they try to sign them up.
Well,
so it's a
hold
real
on.
problem.
Hold on for a second.
There's you have to be clear about this, though. J&J withdrew the allegations that somehow the plaintiffs' folks were involved in this kind of lead generation stuff. They pulled that motion.
They pulled the motion.
Look, in every walk,
they
in
still
every
found
walk,
the information. And the reason they pulled the motion was because they couldn't connect it directly to the plaintiff's attorneys that were in that lawsuit.
well, you know, in every walk of life, whether it's law, medicine, politics, there are the outliers. But the truth of the matter is that there are thousands of mesh cases where women have lost their lives. They've lost their use and enjoyment of their bodies. And the companies have not taken responsibility. You know, they've decided to take a different road. Now, some companies have acknowledged responsibilities. And if we are going to attempt to define the issue by the people on the outside, that's really not fair.
But Chris, you obviously don't condone that kind of conduct. I mean, do you come out and castigate some of your own brethren on your own side of the ledger?
Yes, we have done that. The trial lawyers organizations have done that. We've had private conversations and public conversations, but we can't control the outliers, just like the pharmaceutical companies can't control some of the smaller companies that are doing bad things.
But Chris, it's up to plaintiffs' attorneys to screen their cases and make sure that these are valid cases.
Absolutely, I agree with you 100%.
Okay, let's go ahead and actually look at some of the cause celebs that are in court, in litigation today. Jef, help me out here. I guess the biggest one on the plate right now are the vaginal mesh cases. What are these cases about, and how many are out there?
It's a sprawling litigation. There's 70,000, an estimated 70,000 cases out there. The cases focus on mesh implants that are used to either treat incontinence or to hold up organs that are sagging. The problem with the mesh is that it sometimes erodes, it cuts organs, it causes pain, it makes sexual intercourse very painful, and many, many women are suffering from that particular product. There are a number of manufacturers, more than 20, and it's going to be very difficult to come up with any kind of global settlement.
And
although we have settled with one group already. You know, I serve as lead counsel in New Jersey litigation, and one manufacturer has, in fact, acknowledged responsibility and resolved the cases.
One of the smaller ones, Endo, that's right.
And, you know, hope springs eternal. And we're hoping with a couple of more verdicts, things will get real and we'll be able to resolve those too.
There are cases on trial across the country. A jury just came back in California with a $5.7 million verdict against J&J in the first case of their Abrevo mesh. So there are cases ongoing as we speak across the country.
Gotcha.
So what I think is important, though, is when you look at both the metal-on-metal hip cases, for one example, and the vaginal mesh for another, these are products where it's not just one company with one product out there. There are a lot of companies with products out there, and the reason is because that was a request from the field, from doctors trying to figure out, A, how can we make a hip implant that lasts longer, or B, what can we do for these women with prolapse or for other organ issues? And so those are both examples of products that were developed across the board, and they were tested, they were sent out into the field, and then only years later do we see that there are issues with them.
Well, there's a
so
whole,
those are two examples, and there's many more, where the industry is trying to solve a problem for doctors.
I agree that it's necessary for the problems to be solved. The real problem, as I see it, is when we get in litigation, we too often, discover that key information was not disclosed early on.
Are you alleging that's what's happening with vaginal mesh and hip implants? I know you said it with Risperdal, but are you alleging?
I think we're finding some of the same problems in certain of the products. Red flags were seen. Correct information was not given to the doctors.
Hindsight is 20/20.
Well, you say that, but then when we take the doctors' depositions and we ask the doctors the questions, had you been provided this information, what would you have done? And most of the time, the doctor said, I would have never given that if I would have known all that information.
Well, my experience has been just the opposite. When we asked the doctors about, what information did they have, or did they have appropriate information, they'd say yes. And in fact, from what I know today, I would prescribe that same drug, or this is exactly the medical device that I would give this patient.
Well, then we would have never won the mesh implant cases to this point, because if the doctor says I would have done it anyhow, then generally that's a problem for the plaintiff. Yet there have been many verdicts. Why? Because the doctors get on the stands and they say, we did not have this information.
The other reason there have been verdicts is that in some of the cases, particularly Bard, the mesh that was used was identified before its use as not being fit for human implantation, and it was used anyway. Those kinds of actions are the ones that are going to get companies in trouble before juries.
And it's about knowledge, though, correct, Jef? What do they know and when do they know it?
That is always the question that has to be answered.
So, Jef, where are we with the vaginal mesh cases and with the hip implant cases? And can people start expecting to see settlements anytime soon?
The judge in West Virginia is working very hard and putting a lot of pressure on the companies to try to come up with some sort of global, systematic settlement. It's very difficult. Time will tell whether they're going to do it or not.
And what about hip implants, Jef? This has been going on for many years. How close are we to creating some sort of settlement so people who have been harmed by these devices, or claim they've been harmed by these devices, Terry might say, are going to seek or going to get some relief?
The ASR hip settlement is already in, and it's already $2.5 billion. They just extended it to add more people on it, to add another $400 or $500 billion. They will continue to settle those cases. People should be seeing money from that now. The Pinnacle hip cases, which is another J&J case. J&J won the first trial on that in Dallas. There is another bellwether trial coming up later this year, and there is no settlement in sight on those.
Let's go to Risperdal, because again, Steve, you partnered up with Tom Klein and got the first Risperdal verdict in a Philadelphia Court of Common Pleas not that long ago. $2.5 million for that verdict for a young man who suffered gynecomastia, again, the growth of female breasts, due to the use of that drug. That's what he claimed. $2.5 million verdict. You obviously had to be very happy. But what impact does it have on the thousands of other Risperdal cases that are now being filed across the country?
Well, so far, it seems to have none. We're on trial on another one now. Before that, we had actually settled some, and I thought the company was very, not reasonable, but it was a fair settlement. Neither side was completely happy by a long shot. The court got involved and ruled against punitive damages on an issue now that is going to be taken up. I'm pretty sure we're right. It's going to come back on punitives, and that is creating a major problem. So what do? We keep litigating, and my suspicion is I don't see settlements in the wind. We were offered nothing on this case that we just tried, and I think the battle will go on for quite a while.
And I know, Jef, again, being a journalist, were you surprised by the $2.5 million verdict?
I'm a reporter. I'm not surprised by anything.
Got it. Thank you. That's the right answer.
Good job,
but Jef, let's clear this up, though. When you see a verdict like that come down, don't you think that pharmaceutical companies, obviously they have to react to it? When you see that, even as a journalist, don't you say we're on the road to something here, or does it mean almost nothing at all? We've got to see another 5, 6, maybe 10 cases.
It really depends on the context of the case, the company's approach to its defense. We have companies like Roche and Accutane who have not settled a single case over the course of more than 6, 7, 10 years in Accutane litigation. So every company adopts a different style on these things, and each of them are tied to the individual facts of the cases.
Now that we've had Judge Johnson's ruling, which perhaps is the right one, maybe Roche's strategy in those cases is correct, that those cases were brought before science ever caught up with the lawsuits.
But the verdicts so far, especially in New Jersey and Accutane, and there have been a number of them, did not focus on Crohn's disease. So, he focused on a specific type of case. We'll see how that all plays out. So,
and Terry, of course, this all goes on the appellate court, so you may be right. The appellate courts will have the final word on it. The earlier trials, some of those have been flipped and sent back, and plaintiff's verdicts has come down again on the retrials. It depends on how it's handled at the appellate level, And now everybody will have to wait and see.
I'll have to ask the lawyers this question because, again, I don't think Jef can really opine here. But if there's a lack of punitive damages on the table, as we're hearing in the Risperdal matter, does that make the pharmaceutical company drag its feet and say, oh, we'll try 5, 10, 15, a dozen, 2 dozen cases?
Personally, I'm convinced of that. I may be wrong. And because we're appeal, even though we got the $2.5 million verdict, they already just filed their appeals.
Well, you knew they were going to do that.
We knew that. And we're, of course, appealing the punitive damage. And I think if punitive damages come back into the case, as I believe they will, under those conditions, I think J&J will rethink what they're doing.
Chris, Placitella, punitive damage is part of the equation. Yes, pharmaceutical companies now have a new motivation to get things done, right?
Well, you know, every punitive damage verdict that I've ever gotten, an appellate court has taken away.
Well, to some degree, not entirely.
So, do I think it has an effect? Yes. But I really think that juries, you know, if they're upset about conduct, they make their feelings known in the compensatory phase of the case. And punitive damages may be something that the companies worry about. I don't focus on that. But, you know, most people don't even know in the state of New Jersey that if there's a punitive damage verdict, that case by statute automatically gets referred to the local county prosecutor and the attorney general for evaluation as to whether criminal charges should be brought. That I would worry about a lot more if I was a pharmaceutical company than the number. Most people don't know that, but that actually exists out there.
Although it's usually a misdemeanor and not a felony. But that's another subject.
In the Risperdal case, our judge applied New Jersey law and concluded New Jersey law prohibits the use punitive damage in any drug case. That's what the judge
I guess, Terry, what I'm driving at, and maybe only you have the answer, and again, I don't know if you can divulge that tonight, is what goes into a pharmaceutical company's thinking when it says, okay, we've had enough cases here. We've been able to evaluate this. Most of the verdicts are going against us. It's really time to evaluate all the cases in this mass tort and really start thinking about settlement. What prompts them to say, let's get rid of all of these cases now for a number?
Well, it's essentially the number. I mean, when you start to look at, number one, defending all of those lawsuits through the course of how many years it's going to take, plus your exposure on potential bad verdicts, versus what do we think we can resolve those cases for today, for a number today, you know, those numbers eventually balance out into let's resolve these cases and move on
and again,
to another, you know.
It's not the right nomenclature because it's not a class action, but it depends on how many cases are in the quote-unquote class. In other words, if you're facing 600 cases versus 50 to 70,000 cases as J&J is facing in vaginal mesh, maybe the incentive is not there. Maybe you try more cases.
But it also depends on the science as well. So, for example, we've got the fixident cases where the plaintiffs now can't come up with an expert that will support their theory. So those cases are all going to go away. And we've had Fosamax before we started. So those cases have been going on for, since 2009, both for osteonecrosis of the jaw and atypical femur fractures. Merck refused to settle, and now that strategy is playing out. We were able to take a look at all the facts, and we've had great decisions from Merck on the defense side. So, I mean, there are a lot of factors that go into it. Is the science there to support the plaintiff's theory? How many cases are there? What's the potential exposure?
That goes into technical issues regarding what the jury is going to be allowed to hear. And it's really a matter of denying the jury system. I predict, and you hear me today, predict it, in future years, those cases will come back when the science, which is what I believe it is today, shows causation, but new experts, new facts will develop, and I wouldn't want to be in a drug company situation where 5 years from now, 2 new studies come out and change the whole environment, and all these cases that were concluded to not have merit come back. In fact, Chris has a very good case going on involving talc powder, and I think he's doing a great job on it, where the talc was thought not to have asbestos in it. Guess what? It did. Well, and now all those cases which were dismissed are going to come back, I predict.
I heard Jef Feeley say a little while before that nothing surprises him as a journalist. But Jef, You witnessed the announcement of the Actos, $9 billion punitive damages announced in a court of law. People there in that court of law were shocked if you were not.
Mark Lanier, the plaintiff's lawyer in that case, is one of the premier plaintiff's lawyers in the country, and neither he nor I nor anyone else had ever heard the word billion uttered in a jury verdict, and that caused quite a stir.
And again, $9 billion punitive damages, and the reason for that, Jeff, was what?
Mostly because, again, document destruction. The Takeda folks were found to have destroyed documents in a wholesale fashion, getting rid of computer disks. Juries do not like that. If documents are destroyed or gone, the question is, why are they destroyed or gone? And in many instances, in fact, in this case, the judge was able to give them an inference that said, because those documents are gone, you may infer that they were intended to be gone.
It's very interesting once you start taking depositions, exactly what you find out. And you know, Mark, I've tried cases with Mark, I have cases with him. He's an excellent lawyer. He probably would have rather had a $20 million verdict that he could hold for punitive damages. But I think the $9 billion sent a message. It really did send a message that, you know, you better deal with this problem.
Well, a lot of the work that both plaintiff and defense counsel employ in this area of practice, pharmaceutical litigation, may go away if some things, at least two things, don't change. The Supreme Court and the way the Supreme Court handles generic drugs. I'm not going to say any of you are going to be out of a job here, but let's face it, with the advent of generic drugs, especially over the last decade, this has put a chilling effect on litigation. Generic drug companies, as things stand right now, have little, if any, exposure when it comes to injury.
You know what? Can I just say something? I stay up nights actually thinking about this. It's really scary when you think that how many people, you know, my parents, people's grandparents, that they take generic drugs, nothing else. They have no idea that when they're taking that drug, they have no rights.
And Chris, in Steve Scheller's case, where again a young man takes Risperdal in 2003 or 2004, he gets a $2.5 million verdict because he grew female-sized breasts. A young man taking Risperdal, the generic, maybe 3 years later, he walks away with nothing, even though he suffered the same injury.
Yeah, it's very sad.
That's because of our present Supreme Court. But, you know, it is a problem when the courts intervene and deny people their rights to fair compensation, to a jury trial, and it's wrong. And that's what I predict. Again, I'm making some predictions. That will change in due course. There will be new members of the Supreme Court soon, probably in the next 5 years, and things will come back to haunt the drug companies that do this. Or, like in the state of California, they actually hold the generic company, the manufacturer, responsible for the generic.
Well, right now there's a debate within the FDA, and the FDA there's a proposal to change the rule. The generic drug companies are fighting hard against it, but if they change the rule, they will be held to the same standards as Merck and J&J. And by the way, I bet you Merck and J&J would like them held to the same standards.
Well, here's the problem with that. And number one, it's not the Supreme Court that made the law. Congress made the law, and Congress said that the warnings have to be the same. So we can make the Supreme Court out to be the evil guys, but that's not where it started. It started with Congress. Now,
you're correct.
It's true.
You're correct, but it was a dissent. And 4, if I'm not mistaken, that
a lot of these
agree
cases
with
are, and a lot of these cases are 5-4 decisions.
Am I correct?
Too.
That's 5-4.
It's the way the law is written.
Jeff, I think maybe your writing work might change as well if things continue as they are with generic drugs, no?
Well, I think there's a possibility that things are always changing. Steve's argument is that the approach to this will change as the court changes due to politics. And that, again, is something only the future can tell.
I want to thank my 4 guests tonight. I could talk about this all night. I find it fascinating. For the defense, Terry Henry, hailing from Blank Rome, a commercial litigator, again representing those who make medical devices and pharmaceutical drugs. Chris Placitella from Cohen, Placitella and Roth, the author of the biweekly newsletter, The Mass Tort Update. Steve Scheller has been joining our program now for over 2 decades with Scheller PC, and Jef Feeley, a reporter for Bloomberg News covering pharma and medical device issues. For all of us here at the American Law Journal, thank you for joining us this week. Till next Monday night, case closed.